Interesting. Good morning. We're here on the family law docket A for February 22nd. I'm Commissioner Dave Nelson.
I'm asking for at least a 1 week to 2 week continuance. The father served or got his paperwork served about 3:15 yesterday is when I received it. And so that's less than 24 hours before court. So I'm asking for a 1 week to 2 week continuance.
Mr. Kiyoshi, any response to the 1 week request for 1 week?
Yeah, it's just the declaration that I did read last hearing. So I don't know if, I don't really think we need to set it back a week.
Is Ms. Vaughn here?
She is, yeah.
Here.
Are you okay with setting this over a week as requested by the guardian?
Yeah.
All right. Normally when a guardian asks for more time so that they can do additional investigation, I usually grant that. So thank you both for being here, and I'm going to do a 1 week continuance. So we'll see you back here. Let me give you the date on that. Will be law firm is Cohen.
Thank you, Your Honor. I'm coming in. I'm just requesting a set over on Nonamaker. I apologize. I didn't have this calendared properly, so I didn't realize that it was on for presentation of orders. And I don't believe the other side has made any orders either. So I'm just
seeing any orders in that case. Is Karina Day or David Nonamaker here?
I am. I was told that it was dismissed, so I didn't think I had to turn anything else in.
Well, there needs to be a presentation of an order confirming that, and the Cohen law firm was going to prepare it. So I'm going to put it over a week to get that order, and you should get a copy of it if the order reflects what I decided, and you agree that it reflects that, then you don't need to be here next week. But if you think the order doesn't reflect what I decided, then you can be here. That is number one on the docket. Is Kyle Weiss here?
Yes, I am.
Okay. Ms. Shoemate, go ahead. Why are you requesting a set over?
I didn't get a chance to give Kyle my response.
Okay. Mr. Weiss, any response to Ms. Shoemate's request for a set over?
Yes, Your Honor. According to the records of the sheriff's office, she was served on February 6th. She's had plenty of time to serve me, and every time we end up in this situation, she always asks for a continuance. I'm ready to proceed today. She's had plenty of time. She was served on the 6th. That's about 2 weeks.
And if I may weigh in, Your Honor, this is Beth Fellows, the GAL. I would not served any paperwork from either side.
Okay.
It's my understanding Beth Fellows is no longer on our case. I didn't believe she had to be served.
Have you been dismissed on the case?
No, Your Honor. I'm still listed.
Then that's my mistake. That's my mistake then, Your Honor.
Okay. All right. Ms. Shoemate, you were served on the 6th. That does give you plenty of time to respond. And I know you did file a declaration that I reviewed. However, because Ms. Fellows was not copied with anything, I think a 1 week set over makes sense. And I'm requiring that both parties today send their paperwork to Ms. Fellows so she can review it. Given the allegations and that I need to hear from everyone, I'm ordering that there not be any visitation between now and then. I don't know if it falls on the regular schedule, but I want the visitation suspended at this point. Anyone else requesting a set over?
Yes, I'm requesting a set over.
Okay, Mr. Reeves.
So I spoke to my attorney and he kind of gave me like the website and stuff, but it wasn't the actual website. I filled out the wrong information in respondence to the parenting plan. I have all my papers. I worked really hard. I tried to get them filed and they said it's not in the right form. I did get my declaration and my treatment records in, but my parenting plan schedule was not able to be
There you
submitted.
go.
Okay. I'm just curious exactly what it is that there's not to agree on with 50/50 and no child support.
Jesus.
I think Mr. Reeves should have a chance to look at it. Here's my issue when I looked at your cases. I think we are scheduled for next Tuesday in the minor guardianship case. And these are intertwined. And I think I need to make a decision in the minor guardianship case as to whether we're ready to terminate that minor guardianship before we take the step to do the parenting plan between the two of you. So if we put this over a week, we'll see what happens on Tuesday. Then we'll be back on Wednesday and we can address a parenting plan at that time. Does that make sense?
Yeah, so if he doesn't agree, then what does that mean? We don't get our daughter back, or?
Well, you're seeing your daughter several days a week right now.
Just two nights?
It's kind of a third between you and Mr. Reeves and Marlena Kennedy. And the question is whether this is the time to terminate the minor guardianship. And I want to hear from Marlena Kennedy
This
on
is
that
Kimball
issue
Wilson,
before I.
but I
make
didn't
a
want to set
decision.
over. I was just gonna speak up because you told me last time I could be first in the docket.
Yep, I got your case circled. I was going to call it first. So let's do that now. Caitlin Steyer and Kimball Wilson. Last time we were here, we were looking at needing a hair follicle test from Caitlin Steyer. And if that had come in, we were going to look at increasing the amount of visits or the time of the visits.
Your Honor, this is Beth Fellows, and I am here on behalf of the GAL Ann Height, who is out of town this week. So she asked me to stand in for her and give the court the information that you were looking for. She said that the hair follicle test was not done and an oral swab was on January 20th. It showed positive for meth and amphetamine. The mother also did an SUD assessment on that same date, and intensive is recommended.
Intensive what?
Intensive outpatient.
Outpatient, okay.
Yes, one of the concerns that was brought up during the assessment was her last drug use of meth. She said it was in July of 2022, which with the oral swab test, it is unknown if a new grief counselor has been found, because that was also an issue. Patient has been going good with Karen Dykstra, who is the supervising, but mom's work schedule has changed recently. So she's been only able to make one visit a week. The dad has dropped by a couple of times at mom's home, and dad had reported to the GAL that it's been going okay. So the GAL, Ms. Height, is recommending keeping the visit time status quo, and that basically because of use outpatient, intensive outpatient being recommended, that everything remains status quo.
I graduated.
Go ahead.
Sorry, I was gonna say I went and I did the parenting class at Parents Place. I didn't know what to do with my certificate. It's at home. I told Ann that I did that. So, towards everything else you guys wanted, I don't know if there was anything else I was supposed to be doing.
Okay. All right, thank you. Ms. Steyer, anything you want to contribute? Ms. Steyer, are you here? Court is obviously concerned about what appears to be current meth use that's still going on. And because of that, I think maintaining status quo, which is supervised visits, is the best course at this point. I'm, as a condition of increasing those visits, Ms. Steyer will need to comply with the intensive outpatient treatment. I'm not going to say that she needs to complete that outpatient treatment before I increase visitation, but I need to know that she's well along and that she's in compliance with it.
Hey.
Ms. Soyster, do you say something?
Oh, sorry.
All right, I'll call your case in a moment. Mr. Gilbert is in the booth at the courthouse, and Aaron Gilbert's here. Let me get to my notes here. I required a 12-panel hair follicle test by Mr. Gilbert and a substance abuse evaluation. I didn't see anything in the file. Mr. Lawrence, are you aware of if those have been completed?
I have not seen anything, Your Honor, and I checked Odyssey on Friday afternoon and didn't see anything either.
Mr. Gilbert, have you accomplished?
That was on the internet, and it clearly states it was Portland, Oregon. Measure 110's effect February 1st of 2021, which decriminalized possession of cocaine, heroin, methamphetamine, oxy. So I don't understand what a hair follicle sample is going to prove anyways.
So we're here because your current wife filed a declaration in a protection order case alleging concerns about drug use, about violence, and domestic violence involving your son. That's why visitation is suspended at this time. And we're not going to be able to move forward until you get both the substance abuse evaluation and the hair follicle. And if it shows that nothing's going on now, I will be happy to reinstitute visitation, but I need objective evidence that that's the case.
I can't afford it, Your Honor. And by what she was stating, it was stated in the state of Oregon. If you look at where she stated it, it was the state of Oregon, with measure 110's in effect February 1st of 2021. So it wouldn't matter if I did it in the state of Oregon.
All right, well, I'm sure you're aware of the declaration that I received, which has been recent. What
are you looking at?
Mr. Lawrence, have you had any contact with the parties since our last meeting?
No, I have not, Your Honor. I was awaiting the results of the hair follicle and the substance abuse evaluation. I did have an email communication with Mr. Gilbert's wife, wanting to know how she could get these evaluations and hair follicle exams obtained. And I gave her some information on that, and that was my last communication.
Right.
I can't afford it, Your Honor. With child support, everything else, missing work, I can't afford to do it. So what am I being sentenced for?
Ms. Gilbert, any comment?
I mean, I'm sure he can afford it. So I don't know. I don't know what to do.
Sir, I'm still going to require the test and the evaluation. And I'm going to put this over a month, and hopefully you're going to be able to find the funds in that time.
So if not, how long is my visitation suspended for? What's my charges and what's
It's not going to start. It's not going to start until you do these two things, which is do a substance abuse evaluation and a 12-panel hair follicle test.
So I'll miss some work and everything else, and it wouldn't matter if it comes back positive or negative if it states that I was in the state of Oregon? How are you going to know what state I was in if I was doing it?
You're not being charged with anything.
I'm not being charged with anything. Yes, I am. I've lost the visitation of my kid. I've had to pay the garbage, the license.
Charged you, dumbass.
Park it on my back.
Charged you, dumbass.
Park it on my back.
Charged you, dumbass.
Park it on my back.
All right, so my ruling stands. You need to complete those two, the substance abuse evaluation, the 12-panel hair follicle test, before we consider additional visitation. And I'm going to put this over to March 22nd at 9
So
o'clock.
I'm not being charged with nothing?
No, not here. It just, I'm suspending your visitation because of the concerns that were raised in the declaration that was filed in the protection order case.
In the state of Oregon?
That declaration was filed in a Washington case.
But it clearly states on Facebook and everything else that it was in use. She put drug use in the state of Oregon.
Domestic violence in the state of Washington.
About that. So I made my ruling. Thank you.
Thank you.
We'll see you back here on March 22nd.
The way it goes, dude.
See, Ms. Brewer, is Timothy Brewer here? So last time we were together, and I want to make a record of this, so let me just go to your file. And Mr. Brewer was here. Ms. Brewer was asking for a default order. Because Mr. Brewer was here, I gave him 2 weeks to file a response. And as of right now, there is no response in the file. I wasn't provided a bench copy. And so I don't see any way to go forward other than to enter the default at this time that's been requested by child support worksheets and a child support order from the Department of Child Support. And Ms. Looney, good morning.
Good morning, Hunter.
Have you had a chance to look at those, Ms. Brewer?
Yes.
And do you have any objection to those being entered?
No.
Okay.
Hello.
Good morning, Ms. Soyster.
Good morning.
Child support recalculated the child support due at this time.
Yes.
And they're now asking for $50 a month rather than the $235. Are you agreeable to that?
Yes, I am.
Okay. All right, Ms. Looney, thank you for working with Ms. Soyster on this matter. So Mr. Alexander was present at our last hearing, indicated, and we talked about the prospect of lowering child support. And he said he was in agreement with that. In fact, I think he would accept it being suspended altogether. So I believe he did have notice of this hearing, because we did set it, I believe, the last time we were here. And I believe he understands and is in agreement with this order.
Perfect. Thank you so much.
I think that's all I need to do. So. All right, I received a declaration from Ms. Anschutz that I reviewed. She expressed concern at the court's prior rulings, but at the end of the declaration, she suggested visits from Friday at 4:30 to Sunday at 7. She would like to change the meeting load center, and she'd like an order that the parents would make no disparaging remarks about one another in front of the kids. Have I stated that correctly, Ms. Anschutz?
Yes, Your Honor.
Okay. Mr. Anschutz, let me hear from you first, and then I'll hear from Ms. Fellows.
Okay, so the 4:30 p.m. on a Friday wouldn't work due to the fact that my kids don't get off the bus until about 4, and to drive all the way to Woodland at when they would get off the bus about 4:15 Woodland, we would make the 4:30 pickup time, and for Sunday at 7 o'clock.
Let's start with: are you going to go to?
I could go to Woodland, yes.
Okay, so what time do you think you could get there on Friday?
What time do you think? 5 something? About 5:30.
And what about Sunday at 7? That gets you home about 7:30. Would that work for you?
What do you think about Sunday? Oh, my kids, my 5-year-old goes to bed at 7:30, and then my other two go to bed at 8:30, right? So
Okay.
I'm trying to think how that would work, because usually when they come home on a Sunday, they get, they take showers and they eat dinner, and then they get all their stuff ready for school for the next day, and then it takes a good amount of time.
Okay, I get that.
Okay.
Do you have any problem with an order that you're not to make any disparaging remarks about Ms. Anschutz in front of the children?
Yeah, I haven't made any of those, but I have no problem with that either.
Your Honor, I've supplied text messages of the way he talks to me, and I've heard from the children of things that he says.
Let me go to Ms. Fellows. Anything you'd like to contribute?
I think the Friday at 5:30 would be workable because of the kids getting out of school. I did think that the Sunday at 7 o'clock was a little bit late just because of the travel time and stuff like that. So I could see it be at maybe 6 on Sundays. I think meeting at absolute sense, it's a midway point and it's right off the freeway. So that really works. I did have an additional idea that any days that the kids are out of school that attaches to mom's weekends, that she be allowed to have the kids those additional days. Like if we just have President's Day, if that would attach to her weekend, then she would have gotten Monday. And then the drop off would be the same as it would be on Sunday time wise. So that was my thought for a little bit of additional time that wouldn't impact their school or anything else.
Mr. Anschutz, any comment on that thought?
No, I'm agreeing with Beth.
These Fridays to Sunday, are they every other week?
Yes.
Okay, let's make those changes then. We'll have, first of all, the meeting location at 5:30 on Friday because of the work schedule. And then the children will be returned Sunday at 6. If there's a school holiday that is the Monday after the Sunday, which is the mother's visitation, then the mother will be able to keep the children that Monday.
I would add also, Your Honor, that if some holidays are on Fridays, that she be allowed the Friday if that's a day off of school as well.
Okay, I'll add that. I'm not sure how many Friday holidays we have, unless Veterans Day is usually on the actual date, but okay.
Your Honor, would it be just like holidays, or would that include school and service days also?
If it's a school holiday, so I was going to add and include the school in-service days with that. So if the kids are not in school on a Monday, or I guess on a Friday where it's your weekend, then you would be able to pick up the children, either drop them off later or pick them up a bit earlier. And it is important to the court that there are no disparaging remarks that they make in front of the children. I think one of the most difficult things we deal with is where parents, through comments, poison the children against each other. I don't want that to happen in your case. If it has been going on, it needs to stop right now. And I don't expect it to continue. If there's evidence that there are disparaging remarks made after today to the children, then there will be a sanction for that. It could be loss of time with the children, could be a monetary sanction, but there will be a sanction. Okay? So I'm going to enter a bench order to this effect. If you want a copy of that, I'll be ready in a couple days. We do have a child support, and have the parties looked at the Office of Child Support work documents?
Yes, and I returned it to them.
We did receive the
Any
signed signatures from
objection?
Mr. Anschutz.
Excuse me, go ahead, Ms. Luna.
Sorry, we did receive, Mr. Anschutz had signed that he agreed, so we did receive that.
Okay. All right, well, if we're in agreement, then I will go ahead and sign those orders.
Your Honor, the papers that I received from child support, they have me working 35 hours a week. I only work 10 hours a week, and medically I'm not able to work more hours than I currently do to women issues. I'm set to have surgery in the next 3 to 5 months with the date to be determined. And when I do have surgery, I can't work for a minimum of 8 weeks. I know in the papers, it did say something about my previous job. I only worked 22 hours a week there and made $1 more, but that was a COVID job and it no longer exists, hence to why I transferred to a new job. So I just wanted to bring that up because I don't work 35 hours a week. I can't pay the full of what they're asking at 10 hours a week at $17 an hour.
Ms. Looney, do those comments result in you needing to maybe go back and look at the amounts again?
No, Your Honor. We have imputed Ms. Anschutz at full-time for her current rate of pay. She did provide the pay stub showing her current rate of pay. Previously, she had disputed the hourly wage that we had imputed her at. We believe that she is voluntarily underemployed at this time. We have no record regarding medical conditions, and at this time, it sounds like that's a temporary condition. We don't set our orders based on a couple of months of inability to work. We're looking at long-term when we're setting child support orders in place. So under RCW 2619-071, subparagraph 6, we believe that imputation under the statute is appropriate at this time, and that we would be requesting the $757 transfer payment for Ms. Anschutz.
Ms. Anschutz, what the statutes direct Ms. Looney to do is to impute income based on up to 35 hours a week, which is what they've done. So these worksheets in the child support order comply with the statute, and there's actually not much discretion the court has to deviate from that. So based on that, I'm going to go ahead and sign these.
Your Honor, there's no way I can pay $700 and whatever they're asking a month. And I literally cannot work full time, and it's more than a couple of months. The surgery is going to be 3 to 5 months. I'm still waiting on insurance and a date. And then I'm on state assistance. I receive food stamps. I receive state medical. There is absolutely no way I can pay that a month on 10 hours a week. That is, I literally can only work that right now. And I can provide my medical if needed.
When you go out and cannot work, would you provide that documentation to Ms. Looney, and she can take that into account at that point in time?
Your Honor,
She can connect with the support enforcement officer that would be involved in the case and discuss with them if she needs to have a temporary reduction in the amounts that she's paying. But we would not be looking at changing the amount of the transfer payment that we're requesting. She would be accruing arrears, but they could temporarily allow her to pay a lower amount while she's recovering from her surgery.
And could she contact your office to learn the name of the support enforcement officer?
Yes, Your Honor, we can give her that information.
Okay, what about right now? Like, how am I supposed to come up with $700 some that I don't have?
Again, the statutes lay out what these amounts are, and the court has very little discretion to deviate from that. So I've entered this order, and that good morning, that will be in effect. Thank you. Is Elizabeth Miro here?
I don't know. I saw her this morning.
I'm here.
There she is. Okay. Good.
I'm working. I'm at home sick, so I don't know how to use it on my phone. Normally I use my work computer.
All right, let me ask a quick question. You were in front of Judge Basher within the last couple of weeks, I believe. And that was for a trial setting. And he indicated that he was going to send your case to mediation. Have you received that documentation yet? All right, Ms. Miro is shaking her head. I assume you still want to move in that direction. Is that right?
I actually called the clerks and I was told by a gal last week that I needed to call his assistant, and I have all that information at work, but I was out of town for my brother's wedding in New Jersey, and I got back and I've been sick, so I haven't been at work, so I haven't been able to follow up with that. But they said that I was the second case to do it, so that's really new and they're unfamiliar with how to proceed, is what I was told.
Okay, so did they tell you to contact Ms. Broughton, Bree Broughton?
I don't remember the name I wrote down.
Okay. The reason we're here today is to address child support. Do we need to do that, or is that something that we're now going to just put over to the mediation and address it at the mediation session? Ms. Miro, I guess I'm asking how you proceed.
I just I feel like everything just keeps getting pushed over and pushed over and pushed over. And with the sounds of what I was told by the clerk, they're really unorganized and unfamiliar with how to proceed with that. So I asked her what the difference was, the idea of the way, the new way of doing it. And they said it's done outside of a commissioner. So either way, it's going to be the same. I don't care if we sit down with you, Judge Nelson, or we sit down with someone else, but I just feel like we need to sit down and figure it out.
Mr. Montez, is that your understanding that this was sent to mediation? Did you understand that?
Yeah, we know. We don't. Obviously, we both don't know really what that looks like. But yeah, I mean, I'm here to cooperate and to help in whatever way I can.
All right. I'm sorry for the confusion. I will talk to Judge Basher sometime today and his assistant in order to get this on track. You should receive something in the mail telling you who to contact. And because it's just, it is a program that's just starting, I think you'll be able to get in rather quickly and perhaps be able to resolve all of these issues. If not, then, unfortunately you come back here and we kind of go back to where we were, at this point in time. I will let.
Can you write down, can I text you my address? I don't want to say it on here, but can I text you my new address so you can update it with Judge Basher? Because I gave them my email and I've been checking my email for the information at the last hearing that we had with them, and I haven't received anything either.
So call the court administration. So that's different than Judge Basher's assistant. I want you to ask for my judicial assistant.
Okay.
And give her the new address.
Okay. Okay. All right. So we're done here then today.
So at this point, we're done. And I think I'm not going to set a review hearing. If you go through mediation, you're not able to get her to a resolution. And particularly if you haven't addressed child support at that point, note up a new hearing on this docket to address child support, and then
I'm here.
I will move things right. You're both on the telephone. Thank you for being here. So I did receive the documents from Mr. Hinton asking to set aside the default, the order of default. And I got those actually right after the hearing a week ago. So I'm going to let Mr. Hinton address that motion. Then I'll let Ms. Laura Hinton respond. Mr. Hinton, you'll get to have the last word to whatever Ms. Hinton says, and then I'll make a decision. Okay.
I just ask that you just take into consideration everything that was presented to you. I know that I probably went about filing everything and doing it all a little incorrect. It's new to me. And then on top of it, I've been dealing with like I said, the injury from the motorcycle accident. And yeah, I just ask that you take that into consideration and give us our chance in court. I honestly don't want and haven't wanted any, ongoing issues and so on and so forth. I've been quiet, haven't, and I've been accused of everything. And so with that said, I just ask that you please consider giving us the chance to have our day in court.
Yeah, so I was looking, because I got the paperwork actually that same day as well. And I was looking at one of his exhibits, and it was the one from St. John's Medical Center where he was treated on 10/22. And it says he may return to work on 10/28. He is a general contractor. He is a carpenter. So if he can lift shingles on a roof, and if he can use saws, and the author released him back to go do that, he can turn in paperwork. I mean, that was only 11 days after he was served. And then he goes, and I see the Vancouver clinic, and that's in December. So what happened in the full month of November where he could have responded? He was probably too high. So,
again, I object to that.
Mr. Hinton, go ahead.
Everything is divided out. Okay, thank you, Your Honor. Everything is divided out. He has all of his tools, which were thousands of dollars worth of tools. There is no need to go to court. He lived here for 2 years, and we were married for 5. He had nothing when he came out of prison, and now he has a lot. He has a truck, a trailer, all the tools, the business. He could have kept going if he wasn't using drugs. I got a phone call from the loan company for his big red truck. He had $5,000 to get it out of repo, and now they're looking for it again. So he hasn't made payments, and he is hiding it. They called me asking if I knew where it might be. I don't know where it is. So, he has money. He's just deciding to spend it on other things. He has a place to live. I just want this over with. I've moved on. There's nothing really that needs to be gone over in court.
All right, thank you. Mr. Hinton, any further comment?
Yeah, absolutely. And I've been stopping myself from detailing things and outlining it so far, but I'll go ahead and respond to what she had to say. I don't understand how she gets any information whatsoever because everything has been wrong so far. We could go into detail as far as, the amount of the truck getting out of repossession and whether or not it is being hidden or not. All of it's incorrect. I don't currently run my business after my accident. Not only did I have major memory loss for a long period of time, and I still don't have all of it back. I'm hooked up to a wound vacuum currently for the wound on my leg that has occurred right after I got out of St. John's, and I have been continually having to take care of it. That's from plastic and debris from the bumper of the car. Everything so far has been wrong. It sounds to me like she does have a lot of stuff to say, and that's fine. I just, again, ask you, I gave you my medical documents and so on, and I have abundance of more information with that if you would like. I just I didn't get a fair swing at it. I'm not trying to ask for anything I don't deserve. I got out, worked my butt off, rebuilt the house, did everything, put new appliances, everything, so on and so forth, and as we separated, she damaged the truck severely, $5,000 worth of damage.
All right, we're
yeah, I
really
apologize.
dealing with those issues now. The issue is simply, should I set aside the order of default?
You're right. I will stop now, and thank you for letting me speak, Your Honor. I just ask that you take the motion into consideration.
Thank you. I'm going to get a little bit into the legal weeds here because if somebody asks for a revision of my decision, I want them to understand. I want the judge to understand my reasoning. So there are two defaults. One is an order of default, which has been entered in this case, and the other would be a default judgment, which has not been entered in this case. An order of default, setting that aside, is governed by Civil Rule 55C, which says, for good cause shown and upon such terms as the court deems just, the court may set aside an entry of default, and if a judgment by default has been entered, may likewise set it aside in accordance with Rule 60B. But we're just dealing with 55C because what we're dealing with is an entry of an order of default, which the parties may know I was the one that entered that order. According to case law, good cause under 55C requires a showing of excusable neglect and diligence in bringing the motion to set aside the order of default. In that case, there was an order of default entered, and the court actually found that the attorney acted with inexcusable neglect, but did act with diligence. And so the question was, could you still set aside an order of default if there was inexcusable neglect? And the court said it's still within the discretion of the trial court and upheld the setting aside of the default in that case. So the evidence that Mr. Hinton has brought to the court is that he was served on October 17th. The accident occurred on October 18th. He waited 4 days before he went to get treatment. He went to get treatment on October 22nd at St. John. Ms. Hinton is right. That same document shows that he was released to work on October 28th. It turned out he had a broken hip. And after that, he developed an infection. He got medication for the infection in early December. The court finds that that means that it was likely the infection was beginning sometime in November. He then filed, I believe, a response in this case on December 19th, which was after the order of default had been entered. Well, the facts that I just cited, though, I believe constitute excusable neglect for failing to file a response in time. The second question is whether he's acted with diligence. And I'm going to find there was diligence. He's brought this motion prior to any final orders or judgments being entered. And so that would be in the requisite amount of time. If he waited 3, 4, or 5 months from now, we might have a different conclusion. But at this point, I'm going to find both excusable neglect and diligence, which is what is required to establish good cause to set aside the default under Civil Rule 55C. And before this case can go to trial, if it needs to be set for a mandatory settlement conference for March 8th at 1 p.m. And what you'll be asked for is they'll give you some dates for a settlement conference file and a motion to invalidate which one works for both of you. Your marriage. And it sounds like both of you agree to it. Is that right? There we are. All right, good morning. We're here on the child support contempt docket for February 22nd.
She was present at her last review on January 25th. We have not seen a payment yet for February. So at this time, we would just be asking.
There should be, I just did it over a week ago. It should be there. I mean, unless there's something that with my, no, I put it through.
How did you make the payment, Corey?
I went onto the saw Secure Access Washington online, make a payment. I didn't scribble down the confirmation number this time, but I posted it. I can double check into it, but it's there.
I would assume possibly Ms. Looney that because of the holiday, they may have a delay in posting it. So it's probably they're just not posted.
Yes, and Ms. Sutton has indicated this before, Your Honor, and her payments have posted either the day of her hearing by the end of the day or the following day. So the state is willing to give her the benefit of the doubt. Again, Your Honor, we would just be requesting that if she's unable to pay in full, that she provide a job search and work log for her next review and ask that be set on March 22nd. Ms. McNeil was not present at her last review on January 25th. Mr. Angelico indicated that she was looking at getting into a 30-day detox program. We did not have confirmation on whether or not she had entered that program. But we did not receive any of the alternate purge conditions requested for whether she had gone in or not. We had asked for a treatment plan and diagnosis if she had gone into the, gone into the plan. If not, we had requested some work source requirements, interviewing and resumes and cover letters, as well as a job search and work log. We have not received any information or confirmation about the program.
Thank you, Your Honor. I'm aware that it was recently aware that she had been in a short program, I believe, with Columbia Wellness. And I'll let Ms. McNeil address. She said there was a story behind not being able to get into Rainier Springs. So we'll let Ms. McNeil explain the circumstances.
Yeah. I had went to Rainier Springs because they had told me that if I showed up that morning that they were going to give me a bed. And that was in Vancouver. And when I got down there, they told me that the bed was taken. They told me there was another bed available if I went to Lifeline from there, which is in Vancouver, and that they had spoke with them. Well, when I got to Lifeline, Lifeline told me that they didn't have a bed either. And I ended up coming back to Columbia Wellness because they had an available bed for me. And I was still also trying to get into a 30-day inpatient. And at the time when I had completed at Columbia Wellness, they were still looking for somewhere I could get in.
And are they still trying to find a bed date for you for a 30-day inpatient treatment program?
Yeah, and I also have an assessment I got to figure out when with Family Health to try to get into an inpatient sooner. So
The other matter, Your Honor, in regard to part, she does have, I think, was trying to get on a disability claim. And we had, I think, indicated to the court prior. She did send me, Your Honor, because after she, I think after she left Columbia Wellness or completed the treatment at Columbia Wellness, she did try to go back to the disability claim. They gave her the fact that apparently she doesn't have the right login information, so she had to request it. I was sent yesterday, I think, or late yesterday, the screen shot showing that she's awaiting, that they've told her that it would be provided to her so that she can access that account. And were you able to complete any of the other? I don't remember when you were out of Columbia Wellness. When did you complete treatment with them?
about a week and a half, 2 weeks ago.
Okay. And were you able to do any of the programs through WorkSource, any of the workshops through WorkSource?
No, I was not.
Yeah, the state would just want to inquire as to what date Ms. McNeil has the assessment with Family Health Center regarding trying to find an earlier bed date. And if Columbia Wellness had a potential bed date for her at this time.
And I can get that to you.
Do you have a bed? Have they established a bed date through Columbia Wellness yet?
No, I need to call and find out.
And if she has an assessment at Family Health Center, they do utilize the Toutle River campus sometimes for inpatient that she might be able to get into quicker than Columbia Wellness can find another place.
Is she due back on March 22nd?
Yes, Your Honor. We will go ahead and set her out a month since she's still working on trying to find the correct treatment. We would just make the same request that we did previously, that if she does get accepted into treatment, that we are provided with her treatment plan and any diagnosis, and that if she's able to participate in any online programs at that point, that she would complete the interviewing and the resumes and cover letters, workshops through WorkSource, and that she do a job search work log with her time in treatment counting towards her steps towards becoming employed.
Ms. McNeil, the efforts you're making to get treatment and when you go to treatment, all of that can be recorded on the job search and work log, that you can get a copy of that form from Mr. Angelico. And so I'd like you to keep track of that. This next month, we know that you know what your efforts are to get the treatment. Okay. And then if you do get into treatment, you need to provide the information that Ms. Looney requested about that. For right now, I'm going to suspend the requirement to do interviews and cover letters. I'm hoping that you get into treatment, and we'll pick that up next month, depending on where you're at. Okay.
All right. Thank you.
Rejoined us, Your Honor. We can go back to your case if you'd like.
I do have that confirmation number for you, and it states that it's processing. It has today's date on it. So, but if you'd like the number, I do have it.
Right. Thank you, Ms.
Such a relief. Okay, thank you. See you again.
49-8. Mr. Effine was present at his review on February 15th. He was ordered to report to the Cowlitz County Jail by 5 p.m. That on that date, he failed to report. So we're here today to address that issue. The state's request today is that he be required to report by 5 p.m. today, and that his bail be set at $500 because he has failed to pay for January and February at this time. We would also be inquiring as to whether he was still employed. If he is, we would be requesting that upon his release, he'd be required to provide his work schedule directly from his employer, as well as a copy of the paperwork he stated that he had filled out previously that would put the wage withholding in place from his employer, and that he be required to provide those no later than 4 p.m. on the date after his release. And at this point, he is scheduled for the first week of the month, so his next review would be on March 1st.
Thank you, Your Honor. I'll let Mr. Huffine address. We did get in contact with Mr. Huffine and asked that he be present since this was placed on by the prosecutor. So we will ask Mr. Huffine to address the issue concerning the jail, not reporting to the jail.
I didn't have the money at the time, and I am working, and I don't want to lose this job, so I didn't want to get stuck in jail without a payment. And I knew I owed $250 in 3 days, $250 more. So she says that my bill's going to be $500. I had the $250 now, so I'll have to get the other $250 now too.
Your Honor, at the last hearing, Mr. Huffine stated he had the money to get himself out on that date, and now he's stating that he did not have that money to get himself out on that date. We're at this time requesting that the court require he report and that his bill be set at $500. We're also requesting to amend his ongoing direct contempt order, that if he is again ordered to report to jail and fails to report to jail, that a bench order would be entered immediately without a hearing.
And the contempt will accomplish what?
I'm sorry, Your Honor.
You said a contempt would be entered without a hearing?
No, we're requesting that his direct contempt order that's already in place
Right.
be amended to include that if he is again fails to pay under that order and fails to report to jail as ordered, that he would have a bench warrant issued
I'm sorry.
under that contempt immediately without a hearing.
Mr. Angelico, any comment on issuing the bench warrant?
Not, no, Your Honor, I don't believe I have a comment. I know that Mr. Huffine had been, and I believe is still working at Lowe's. And I know when he basically is indicating that he was concerned about losing the job. I can understand that. As far as the payments, he had I believe he said he has $250 today, and I believe that was going to be applied to the January one with the requirement that he have a payment posted by, I think, the 25th of February, which would be basically in 3 days to cover February.
Mr. Huffine was about to start work and the state had asked for jail time. I held off so that he could start work and make a payment. Payment was not made. Last week, I ordered that he report to jail for 5 days with a bail of $250. If he posted the bail, then he would get out. He indicated he had the money and that he was going to show up. He didn't show up for jail. I feel like the court has been exceptionally generous with Mr. Huffine over the past few months. And that generosity is run out, basically. So I'm ordering you to report to jail at 5 p.m. today. The bail will be $500. If you do not report, I will sign a bench warrant for your arrest. And again, if you're picked up and brought to jail, then the bail will be $500. And we'll need you back here next week on March 1st at 11 a.m.
Okay.
All right. Thank you, sir.
And Your Honor, will you be entering another bench order regarding the report to jail today for the $500 bail?
We're going to need another. We had a slip we did yesterday, and we're filling it out right now. So
Thank
we
you,
will
Your Honor.
provide that to the jail shortly after this hearing.
Thank you, Your Honor.
All right. Thank you. Thank you, Mr. Huffine. You're free to go.
494-F08. Mr. Friend did not appear at his last review on February 1st. He was ordered at that time to make a payment of $500. That has not posted. We did know that he was sentenced in his DUI matter to 6 days, and he was to report at the end of this month. So if he has we would require if he has a specific date when he would be reporting. We did also receive this morning an email that Mr. Angelico sent with a letter stating that he has a promise of employment from Golden Ladder Interiors. It was vague as to when he would begin and how consistent the work would be. We would also be requiring as to when that start date would be expected and how often he would be paid.
Address them, but he currently, I believe, is required to report to the jail, I think on February 26th. He has, I believe, 10 days to do starting February 26th. The promise for the employment one, where the letter itself basically says once he's released from jail, so his intent is once he's released to contact them. And I'm not sure if Tyler, if you know kind of how much work that they have, how much time that you would be working.
Well, it wouldn't be by the hour, it's by the jobs, and each job's a different amount and time frame.
Do you know?
But I know she's working on having me scheduled for one when I get out, though.
And do you know how?
So I'd be going right.
Do you know how often?
How often would I get paid? Probably roughly every 2 weeks.
And do you think it's going to be consistent, that the number of jobs are going to be consistent, or is it just whenever they need you?
Well, it's going to be whenever the jobs are there, but I also have a couple other people that are willing to use me also to help me fill in if they need me also. So if I have 2 or 3 of those, I'll be okay.
Okay.
I just got to get through this jail thing. It's holding me back with everything.
Your Honor, at this time that we would
And
just.
we're about as broke as we can be. We're about ready to have our power shut off, and I had to ask our landlord to let us go for a month until I get out, and we're just on our last little dollar here.
All right, Ms. Looney.
Your Honor, we'd ask that his next review be set for March 22nd. That should give him time to serve his time for the DUI as well as to begin work. We would want to see him making payments as soon as he's starting to get those checks coming in. We would at this time reduce our request for a payment to the $250 that we requested previously from the $500, seeing that he will be spending some time where he is definitely not going to be able to be seeking employment for a few days. So we would request that he be ordered to pay $250 by the hearing for March 22nd.
All right, Mr. Friend, you just heard Ms. Looney, but we need you back here on March 22nd and prior to that date to pay $250. And we also would like confirmation of your employment and some idea of what kind of hours you're working.
0495-08. We are here to discuss quashing Mr. Ibanez-Rosales' warrant that was issued last week. Excuse me, I'm sorry, on February 8th, not a few weeks ago. We did receive an email from Mr. Angelico requesting he be set on this docket, where they also stated they anticipated that he would be making a full $400 payment. The state has not seen a full payment or a partial payment. We have not received any job search or work logs since October. At this time, Your Honor, what the state is looking at is the fact that Mr. Ibanez-Rosales has not made any payments for 14 months. That means it's been 14 months since Mr. Ibanez-Rosales' child has gotten any support from him since this case opened. He has made a habit of promising to pay or being ordered to pay partial payments that we were trying to step him up towards those full payments. Since August, he has failed to make the payments and then failed to appear for his following hearing so that he can be held accountable for his failure to pay. At this time, what we're requesting is that Mr. Ibanez-Rosales be required to report to jail by or make a payment in full by Friday at 1 p.m. And have proof to the prosecutor's office by 1 p.m., either with a screenshot or receipt of a payment in person at Walmart or another location. And if he does not make that payment in full by this Friday, February 24th, we would be asking for a one-time requirement to report to jail, and that his bail would be set at that $400 full purge amount, and that we would ask that he be required to report to jail by 5 p.m. on the 24th.
Are you asking for 5 days?
We would be asking for, if Your Honor would order the 5 days or until he can pay.
I believe Mr. Rosales has made a payment of $200. Was this payment, yes, when was the $200 payment made? It went through the mypaymentportal.com. The image indicates that there may be a delay of up to 7 days delay for the state to receive the payment. There you are.
I made the payment. I made the 400 payment. That's the one, the 200, and I can send you the other 200 that I pay. So it's the 400 that I can send you the confirmation and the receipt for the 200 and 200.
So the one that I have was made. Do you know when that was made?
Yeah, they make yesterday both payment, but I send you just one. I'm gonna send you the other one that I have. I forgot to send you the other one, but it's the 400.
Okay, so if you could make sure you send it the same way you sent the other one.
Yeah, I send it right away.
And again, was that made through mypaymentportal.com?
Yes.
Okay.
Yeah, I was making online.
Okay.
Yeah, I called them, but they say they cannot accept payments on by phone, so they made the link for make the payments online.
With the new information, we'd request that Mr. Angelico forward the confirmations that he gets from Mr. Ibanez Rosales, and at least set this over 1 week to confirm that those payments have posted to his account.
All right, Mr. Rosales, we're going to put this over 1 week to confirm that those payments have been made. You need to give the confirmation to Mr. Angelico. If the payments have not been made by next Wednesday, if we don't get confirmation of that, then what the state is requesting will be ordered, which is you'll be required to report to jail. And I'm still deciding whether I'm going to set it for a set period of time or until you pay what's owed. But you need to be here next week on March 1st so we can follow up with the payment you told us you made.
Okay, I'm gonna send that to Mr. Angelico, and yeah, okay, that's fine.
Send the screenshot as soon as you can. So with his appearance, Your Honor, if we can quash the warrant and then set it to 3-1 with the expectation that I have one of the payments to send and the other receipt, I'll wait for that receipt.
Yeah, I'm gonna
at the same time.
I'm gonna send you the other one.
Ms. Looney, what's your position on quashing the warrant?
Your Honor, we'd request that it remains in place for the additional week. At this point, Mr. Ibanez Rosales has made multiple promises to pay, and we have not seen him follow through.
We placed it on this calendar, Your Honor, for that express purpose. If Mr. Ibanez is in any fashion has any type of traffic infraction, if he's driving, if he's contacted by the police because of being a witness to anything, and they see an existing order, they normally would take him into custody. So
I'm aware of that, but we still don't have confirmation that there's been a payment. So once there's confirmation of at least one payment, I understand there were two $200 payments. Once there's confirmation of at least one payment provided to Ms. Looney, I want Ms. Looney to email me that information, and I will immediately quash the warrant at that time. I'm assuming that information is going to show up by this afternoon and we can quash the warrant by today or tomorrow.
I can actually.
But if we don't get that confirmation, then the warrant's going to stand. There have been a lot of, as Ms. Looney indicated, promises in this case. Again, we're being told there were these payments, but we really haven't seen anything to support it. So until I get objective evidence that the payment's been made, the warrant's going to stay in effect.
Actually, Your Honor, if we go on to the calendar, for the rest of the calendar, I can actually email the receipt for the one payment that I have currently.
Okay, if we see that by the end of the calendar today, do you receive anything from Mr.?
We just have one final matter, Your Honor.
I haven't received the second one. I sent the first one. I just emailed it to Ms. Looney on the receipt that we had from his payment from a couple of days ago.
I did just receive that, Your Honor, that shows he did make a payment for $200, and I can forward that to you right now if you'd like to have that to be able to sign in order to quash that warrant.
Appears to be a receipt for child support from payment portal. So based on that, then I will quash the warrant. Ms. Looney, will you prepare an order to that effect?
We will, Your Honor.
All right, good morning. We're here on the minor guardianship docket for February 23rd. Okay.
Chuck Angelico here, Your Honor, in regard to attorney for both kids.
All right, and Mr. Goodday, you were able to meet with your client.
Your Honor, we've been playing some phone tag. Apparently she lost her voice last week. She was unable to talk to me. She did return my calls though and left me a message letting me know the situation. And we're in contact via text now. I'd request if we could just have one more week. Hopefully we can have an appointment tomorrow, but we're in contact now and her voice is back, so we should be able to get this done.
And then, Your Honor.
Okay.
We're ready to go.
Mr. Hebding, any objection to putting this over one more week?
No.
He is here. You may not see him, but he's on my screen. Any objection, Mr. South, to putting this over a week?
No, let's go ahead. We need to get moving on this, but
here's, I guess, if we put this over a week, I'm going to want to know if the emergency minor guardianship is opposed. And if it is, then we're going to have to set a time to have a hearing on that. How do I get out of here? Anybody else on that case? I see an iPhone. Could you identify yourself?
I'm sorry, Your Honor. It's from the last hearing. I'm trying
That's
to turn
from the
you-
last hearing. Okay.
Yeah, but I'm having a little trouble. So hold on just a second.
Okay. All right, Ms. Morris-Teff, you're petitioning to be the guardian of Annabelle.
Yes, because Michael is letting her put herself in danger. She's ran away from the shelter that he's staying at multiple times, and it puts her in danger. And not once have he chased after her or tried to stop her. I have Marcella, the biological mom. I'm here at the courthouse as well. She wrote a note saying that she wants me to have custody too as well while she goes to treatment, because she feels that her daughter's in danger. Also, Annabelle stated that she feels unsafe with her father to CPS when after he assaulted her multiple times and let his girlfriend assault her too by slapping her in the head. And we had to take her to the hospital to get checked up, and because she was having bad headaches, and they said that he gave her a minor concussion. And so I also applied for a protection order too as well. At my house, she's safe. That's where they lived at before he moved out and went to the homeless shelter. We were staying together, but Annabelle has her own room there. She has her own privacies, and I take her to school every day. She's been with me since January, beginning of January, and I've been taking her to school. I just feel like her safety is at risk when she's with Michael, because his concern is not on his child.
All right, let me go over a couple things. First of all, I denied the immediate emergency order, and I'm not going to change that. Here's Michael right now. He's coming in.
Oh yeah, I was trying to come in too. I'm at the courthouse too. I can bring you the letter too from her biological mom.
Just hold on a minute. Let's get Michael connected. I can hear you. Can you stand still, please? Are you at the courthouse?
Yeah, I was coming upstairs.
Why don't you just stay there? It's fine. If that works, I
Okay.
can hear you just fine. Mr. Teff, do you want to unmute yourself?
Yeah, I'm here.
All right, thank you. Alonza Morris Teft is asking to be the guardian of Annabelle. And I indicated that there was a request for her to be the immediate emergency guardian, and I had denied that earlier. I note there's a parenting plan in place that gives custody of Annabelle to Michael Teft. I did note a number of protection order filings involved, but Ms. Morris Teft, I wanted to go over a couple things with you. First of all, on your petition, you did not list the mother's name, and there clearly is a mother here.
Yes, I couldn't get in contact with her at the time, and we thought she was in prison. However, I did see her last night, and that's why I got this letter that I was trying to turn in, where she wrote a letter where why she felt that I should have custody of Annabelle as well, and that while she goes to treatment and gets better for herself, that I was trying to bring to you, that she even signed and date.
All right, just
hold
on a minute.
In danger with Michael.
All right, I guess the issue though for me is you didn't list the mother's name in the petition. So the first thing I need you to do is amend your petition to list the mother's name, and then you're going to need to serve her with the petition. She may know about it, but there needs to be a formal service. The second concern I have at this point is in your disclosure of criminal history, you indicated that you had no felony convictions. And I've got the felony judgment and sentence relating to you for 2019, showing a violation of the Controlled Substance Act and a violation of a domestic violence protection order. So you agree that those apply to you? All right, so I need you to amend your declaration of bankruptcy and criminal history to show that you have those two charges, okay? Mr. Teft, let me hear from you. What's your position on this proposed guardianship?
I'm not for it. I'm not for, I'm the father of my daughter, and I intend to continue being the father of my daughter.
Okay.
I don't approve of anything that she's doing as far as when it comes to my child, especially with what was just brought up regarding her felonies. She has past drug use. She's bankrupt, clearly, and we're going through divorce. And
I am not bankrupt.
Regarding the mother,
let's let Mr. Teft speak.
You ran over the baby mama, the mother of the child.
Regarding the mother, I know the fact that the mother would never want anybody other than myself to be a parent, She's always been supportive of me being a parent, regardless of what we've been through, so.
All right. So what typically happens?
Your Honor, that's why I have the letter right here that Marcella signed, saying that she felt so comfortable.
Let me go on, okay? What typically happens when these cases are first filed is I appoint somebody called a court visitor that helps Ms. Morris Teft with service issues and gives the court kind of a understanding of the relationship of the parties right off the bat. So I'm going to do that in this case. And so let me tell you who that's going to be. And she will be in touch with both of you regarding this case, and we'll want to interview you and find out what your positions are. Okay.
Okay, yeah, because he's homeless. He's in a homeless shelter. I have actually him in the house. So why he's trying to say I'm bankrupt? That don't make no sense.
Okay. At this point, we need to pick a future date. And I need to give Ms. Farr time to meet with the parties, and I don't want it to go too far out.
Yeah, I have a question, Judge. Prior to meeting Ms. Farr, I'd like to request, would I be able to have the orders for the protection order against me dropped so I may be able to attend to my child? You know, it's been, this is the second time the protection order has been put. It's interfered with my parenting. I haven't got to visit my child.
She's terrified of him.
Right. There's no order in this case that prevents that. If there's another protection order in a protection order hearing, I can't address that in this court.
So Jill Carmi, we just had a court hearing on the 21st regarding.
Oh, and she put it over, didn't she, to March 6th?
Yeah, she put it to March 6th, but everything was based on the decision today.
She said what?
She wanted us to get this taken care of this first. That's why she put it over.
Oh, she wanted me to take care of this first.
Yes.
Yeah, she wants this to get established and taken care of first about with the guardianship.
Honestly, Judge, I think
I
think regarding everything right now, she don't have no papers of even being a guardian besides the temporary orders that she had already put. She's just trying to take custody away from me
and I have
from being a
letters from
parent.
the
She's
mother.
not even the biological mother, so.
Okay, and I have letters from the mother right now because I seen her last night with her signature and date. And Annabelle doesn't want to be with you because she feels unsafe with you.
All right.
You let her
like I
run
said,
away one time to put her life in danger.
Here's what I'm going to need to do then.
When I had left, Judge, can I just say one more thing? When I had left, due to the protection order my wife had put on me, along with the divorce, it was a good solid month that I was already at the community house with my daughter, doing everything that is required of me as far as a community house goes. And they're supportive towards my child as well. They make sure we're on a set schedule, everything. Counseling,
because Annabelle said
housing.
people snuck into her room and you locked
I can bring all that stuff into, I have a letter written
right here. She
from the community house.
She can speak for
All
herself.
right.
If I may be able to speak, I
Ms.
can
Morris
bring
Taft.
stuff in to show that I'm doing everything I'm supposed to be doing. Plain and
thank
simple.
you.
It was a good month after that order that my child was with me before any of this interference had happened. I missed my daughter's birthday, the following month after, based on the temporary protection order. Just to have time wasted in court, she dismissed that order, and then she went again to file a second order just to keep my daughter away from me.
Okay, Mr. Taft.
She was not.
She ran away to my house from the community house. That's a
And
far
school.
that's a far place to run.
And school.
I can't make a decision regarding that protection order until I have a chance to review it. And so now it sounds like to me we need to put this over a week. Whatever requirements are in that protection order, I'm going to leave in place, but I'll address it a week from now. So that's going to be on March 2nd. And I'll also talk to Commissioner Carmi about it also.
All right.
So at this point, let's come back on March 2nd. I'm going to appoint Sherry Farr is what's called a court visitor. She investigates things.
Yeah, he tried to,
and then we'll go from there.
sorry, Your Honor. He tried to also make an anti-harassment or making up lies and having people write false statements about me, which is perjury. And I have proof that he's lying about those statements as well. And
he also tried to say that he broke into. He also tried
All right,
to break
I'm not taking any testimony right now. I understand I need to address the protection order. At some point, we might have a hearing where everybody will testify under oath, but we're not doing that today. Okay.
no, I was just trying to say, like, when you talk to her, if you can check in about that too, because I feel like that, that was unnecessary. And
all right, I'll talk to her about it.
thank you.
Okay, let's have everybody back here then on the second, and we'll address the issue of whether the protection order will continue.
What
And
time?
All right.
What time on the second?
10:30, just like today, and it will be on Zoom, just like today.
Okay.
Judge, is there a number or anything I can get a hold of Sherry Farr? I know she's supposed to get a hold of us.
She'll get a hold of you, but you can Google her. She's in Vancouver. You probably can find her.
And how is she related to this case as far as being an investigator?
I'm appointing her to be an investigator, and under the current statutory scheme, she's what we call a court visitor. It's just what they've adopted. And she's basically a neutral party that looks at everything.
Okay.
Okay. And it's paid for by the county because it's based on whether the child has any income. And I'm certain, and every child that's appeared in front of me doesn't have the income to pay for a court visitor. So we always have the county pay. Okay.
Okay.
All right.
March 2nd. What time?
Say that one more time.
It's for the set over, the week set over.
Oh, March 2nd, a week from today at 10:30.
Okay.
Okay, I'll see you then. Thank you.
Thank you.
Both.
All right.
Okay. All right, Ms. Oxford, you're asking for an order that you be allowed to sign a passport application without the need for the father to sign. You want to tell the court why you're asking for that order?
We're supposed to be going on vacation, and I have asked him to sign it, and he has not. So I'm just went this way instead.
Okay. Mr. Goyce, do you object to the issuance of the passport?
No, sir, I do not.
All right. Are you objecting to this order today?
No, sir, I'm not.
Okay. And
Okay.
when I get it, I'll sign it. Okay.
Okay, thank you.
All right. Thank you both. You're both free to go. What I read is that you both agreed to a change in the parenting plan, I think because of Mr. Morgan's change in work schedule. Is that still the case?
Yes, Your Honor, that's correct.
Okay. So I've got an order for adequate cause. I'll sign that today. And if both of you want to sign off on the changed parenting plan, will you be able to do that?
Today?
Not well, in the next few days.
Yeah, that should be able to be done.
Okay. If you both sign off on it and then give it to the clerk with a sticky note on it that says it should go to Commissioner Nelson when it comes in. Okay,
Awesome.
but I'm going to need both your signatures. And if it's easier, I'm okay with the email signature if you can't, if it's not easy to get together.
Okay, it shouldn't be a problem. So I'll just let him know. I know he said he was going to try and make it today. I think he got busy with the
He's
snow.
here. He's on my Zoom call. Mr.
Oh, there
Morgan,
he is. Okay.
Can you hear me, Mr. Morgan?
Yes, I can hear you.
All right. You agree that the parenting plan can be changed. I think it's being changed to accommodate your work schedule.
Yes, that is correct.
Okay. So when the new parenting plan is prepared, then if you would sign off on it and get it to me, then I'll go ahead and sign it.
Okay, yes, I can sign it today or tomorrow.
Okay. Great. Thank you both.
Thank you very
If
much.
you served them, you probably could, but I appointed Ms. Farr to assist with those service issues. Were you able to talk in the last week or two?
We have,
Okay.
sorry.
Go ahead, Ms. Farr. What's the status of service at this time?
So well, when I talked with them last, we don't have service yet. They did have an address to attempt service on Dad that his mother gave. We still need proof of service filed for Mom. And we also, they also are going to file a standard petition. And so I suggested that they do that and then serve everything all at once.
If you could serve everything at once, that would save some money.
Yes.
Well, it looks like I should extend the immediate emergency guardianship. The only question is, how far should I put things out at this point? Ms. Farr, what would you recommend?
Well, I think Ms. Woodworth, how long will it take you to get the petition prepared and get service on Dad, do you think? Do you think you could do it within a week?
I'm going to try my best. Yeah, I'm going to try to get it done as soon as possible. I would like to get this as soon as possible over with. So yes, I believe a week would be just fine.
Well, that sounds optimistic to me. A lot of things can go wrong in a week. Why don't we go at least 2 weeks to March 7th, okay? And so we'll check on the status of service at that time and see if we can go forward with the emergency petition at that time.
I'm here.
All right, good. And Brandon Ervig is here, and I see David McCoy is here. Let me start with Ms. Smith. There was a facility that Ms. Ervig wanted to go to, which would involve taking the child. I know you were hesitant about that, and I appreciate that. But I did ask you to check into the facility. So what have you found out in the last week?
Yes, Your Honor. So I did that offers the PPW inpatient treatment. In speaking with them, it was indicated to me that the first step in the process is submitting to a drug and alcohol assessment. The assessment will go through a clinical review, which will take approximately 2 to 7 business days. If the individual is approved, at the time of the call last week, they had 1 bed available. If the bed is no longer available, Ms. Ervig will need to wait till March, and there is for sure an opening pending in March. The facility indicated that regardless of whether Ms. Ervig has physical custody of the child, they would still allow her to engage in this PPW treatment. The rooms, the court had indicated that there was concern whether the parent and child would have their own room as accommodations or whether it would be like a communal setting. The provider indicated that they are shared rooms. So it would be 2 or more families sharing a room. The provider also indicated that should Ms. Ervig decide to leave inpatient care, the facility doesn't have the authority to retain custody of the child. So if Ms. Ervig was to leave, Parker would be in her care. They just simply don't have that kind of authority to keep the child. In regards to the provision of offering Mr. Ervig regular status updates or reports, the facility is happy to comply with any release of information, but did note that all releases are revocable at any time. So they just asked for us to consider that in moving forward. The facility also indicated that they typically do, Ms. Ervig referred to them as a blackout phase. They call it a refocus phase, typically lasts about 2 weeks. But the provider was not sure whether this refocus phase was still being honored at that current facility. There's no 2-year monitoring at this facility. The only monitoring that would occur is that of which was accomplished at the PPWM patient. And I also spoke with the CPS worker that has been involved with the family, Miss Tracy Fowler. She indicated that in general, the department is in agreement with parents engaging in inpatient treatment and would support that. And typically the department is in favor of reunifying the parent with the child, assuming that the parent has accomplished some time. The Ms. Fowler indicated 2 weeks or more of sobriety before the child was brought to the care of Ms. Ervig. Ms. Fowler did indicate there is no formal CPS investigation that's currently pending related to mother and child.
I already got my evaluation done. It's been done for a few weeks now. So there's no wait on that.
You got the assessment done at that facility?
I got the assessment done and it's been faxed over to that facility. I got it at Family Health Center in Longview or in Kelso. And they faxed it over and I got that done probably a month ago.
I think you indicated, Ms. Ervig, that there was going to be 7 days when you needed to go in before you could take your child at that time.
I guess it's 14, says Ms. Smith. I'm not sure. That's all the information I could find out without like actually going to the appointment to set up being a patient there. And I couldn't do that without your guys' permission. So I can only go so far, you know. But I guess that there's a 14-day period, she said, a blackout period before Parker would get brought to me. I think it goes like case by case basis. And so I would have to go to my initial appointment before they would tell me exactly how many days it would be. But like she said, there's only one room available. And last week when I called, there was only one bed available. And so if I don't hurry, I would have to, wait till March.
Okay. Brandon Ervig, let me speak to Brandon Ervig a moment if you want to unmute yourself. Is there anything that Ms. Smith brought up that affects your opinion that Parker should be able to go with Ms. Ervig to treatment?
No, the only worry I have is, Casey walking out. As long as it's made clear that if she walks out, Parker is to be returned to us immediately. That's my only concern.
I absolutely have no problem honoring that, Your Honor.
Okay. Ms. Smith, did you indicate that they would agree to treatment at this facility, whether she was with Parker or not?
Correct, Your Honor. So the requirement is that she be a mother, whether she has current or will later have custody of the child is not a condition of acceptance into this inpatient facility.
All right. And how did you determine how long the treatment will be at the facility?
It's approximately a year, but it's based on the assessment and the clinical review.
Approximately a year, did you say?
Yes, Your Honor.
Okay.
6 months.
Okay.
6 months of inpatient, and then there's follow-up care that lasts maybe a year, but 6 months is the maximum time they keep you at the inpatient facility.
Mr. Ervig, if I left custody with you, would you be willing to bring Parker down to the facility on a regular basis to see Ms. Ervig?
No, that can't be. She has to go there with me or I'm not allowed in the program.
Well, that's what Ms. Smith has told us is not necessary. She said,
No, she said I don't have to have
in the
custody.
program. but you don't have to have your child with you.
No, I don't have to have custody of her, but she has to be with me, or I'm not allowed in the program. I have to be a mother. My child has to be with me. I just don't have to have physical custody. So my brother can have custody, but Parker has to be there with me, or I'm not eligible to be in the program.
Ms. Smith, can I ask you to clarify that again?
Yes, Your Honor. So the provider indicated that Miss Ervig does not need to have physical custody of the child in order to engage in the PPW inpatient. The requirement is that she is a mother and does have children, but they do not need to be in her care.
No,
Mr. Ervig,
yes.
Mr. Ervig, let me go back to you. Would you be willing to bring Parker down on a regular basis for visitation?
Yes.
I'm not going to the program without Parker going with me. That's the only reason why I want to be with my daughter. She's been with me her entire life. She didn't even know my brother when my brother took her from me. And I want to be with my daughter. That's why I was willing to go to this program, so I can be with her. If I'm not going to be with her, I'm not going to the program. That was the reason why I was going. I was willing to go do 6 months to be with her. If I'm not going to be with her, then, yeah, no. I'm not going away for 6 months in hopes that my brother will show up with the visitation of my daughter. That's not what's happening. And Brandon already agreed that I could take her, and he was okay with me going with her. He thought it was a good idea. He told me at the beginning of all this, he just wanted me to get treatment and everything to get better. And that's what I'm doing. So I don't understand why it's an issue that she goes with me. I'm her mother. My father's right here. He feels exactly the same way. I mean, he can speak as well, that this is insane and that I should have my daughter with me. She's never been without me longer than 24 hours in her entire life until all this happened. CPS came to my house and did an investigation the day before my brother took her, and they had no reason to even open a case on me. They said that she was well taken care of and everything was fine. The next day, my brother took her from me. I don't even understand how that's possible. He told me he was taking her to a pumpkin patch and never returned her.
Ma'am, the reason that you're going into the program, what should be the reason, is for you to get the treatment you need so you can be the best mother you can be to Parker. Concerns were raised last week. I wanted to address them. The one concern that keeps coming up over and over is the concern that you may leave the state with Parker. I wanted to.
I don't know anybody out of state.
Ma'am, this is my turn to talk.
Okay.
All right. Thank you.
Okay.
The one concern that keeps coming up is that you may leave the state with Parker. Now you say, no, I'll never do that. But I wanted to ensure that that would not happen by having the facility agree that you would not leave or be able to leave with Parker. But what we've learned today is that they don't have the ability to do that. And that creates a significant concern to me. The other concern I have is that you've stated that the only reason you want to go to the facility to get treatment is if you have Parker with you. Honestly, whether you have Parker or not, you should be concerned about your own health. And if you can get into this program, I hope you do, whether or not Parker is with you.
Would you go somewhere 6 months without your child? That's insane. I'm not going without my child. I want my daughter with me. She's never been away from me. Of course, I want her to be with me. If my personal life is a worrisome to you guys, I'm willing to go to a facility where I'm monitored with her so I can be with her. I don't understand I don't understand any of this. And my brother already signed the paper saying he was okay with this happening. I don't even know anybody out of state. I would never leave state with her. When I go to my visitations, I take her outside in the front yard. We walk around, we play. I could jump in the car and leave right then. I don't.
All right. At this point, because the protections that I wanted to see apparently do not exist, I'm not going to agree to allow the child to go with Ms. Ervig to this facility. That leaves us with the question of whether we should enter an emergency guardianship order. And it seems to me we've got Ms. Ervik who objects to that. Mr. Ervik who is asking for that. I think Mr. McCoy agreed to it. But we need to have a hearing on that issue because I may, I don't know if I'm going to grant that or not.
What is it I agree to, Your Honor?
What's that?
What is it I agree to?
Did you agree that Mr. Brandon Ervik could be the emergency minor guardian?
Well, if it's between him or anybody else, then yes, but I would prefer the child be back with their mother.
Okay. Well, I'm not holding anybody to anything at this point, but I am indicating that we're going to have to set a hearing on the issue of whether an emergency minor guardianship is entered, and then Mr. Ervik can decide if he's going to file for a full guardianship. Let me ask everyone, I can do this as early as a week from now, or we could do it 2 weeks from now. What would the parties prefer to have that hearing? Ms.
Your Honor,
Smith?
can my father say something?
Right now, we're really picking a time to do a hearing as to whether I'm going to enter this particular order. If he wants to testify on your behalf, he can do it at the next hearing.
Okay.
All right. Ms. Smith, were you looking at your schedule?
I am. I just wanted to confirm this is a evidentiary hearing for.
It will be an
people who can
evidentiary
testify.
hearing where I'm going to have to apply the standard in the code.
Okay.
So we could either do it on the 28th or the 7th of March. All right. Well, not hearing from anyone. I'm going to do it sooner than. I want to do it sooner than later, so we'll do it on February 28th. At 9 o'clock. I'm sorry, at 10:30. If anybody has any witnesses that they would like to testify, they can do that. If you want to review the standard that I'm going to apply, the standard is in what we call RCW 11-130-225. That governs the appointment of an emergency guardian.
What was that RCW, Your Honor? 1131-225?
11.130.225.
Thank you.
You'd be able to Google that and it will come up. And you can review the language of that particular statute. Now I'll get word to Mr. Anagnosti that we're going to be having the hearing next week. Okay. All right. I think that's it on this matter for today, and I'll see you all next week.